as his reaction is concerned. So we'll be trying to get his word as soon as possible. Apparently, they'll not be addressing the media from the podium. As we wait to hear from them, the counsel, James Orengo and Raila Odinga, are currently consulting so that shortly they can address the media. Of course, flanked by the other councils, Feroz Noroji, Otiende Amolo, and several others. As I was saying, that we'll be expected to hear from Raila Odinga on what the next move for the National Super Alliance as we approach the presidential election, which currently IBC has gazetted the date of 17th of October for the holding of that election. So that would give about 27 days to that date. But of course, IBC has until the 31st of October to hold the election and be in accordance with the 60-day limit that has been granted by the court, of course, based on the constitutional provision that a fresh election must be held within 60 days after the nullification of an election. And this was nullified on the 1st of September. And of course, the other matter that has been of contestation is in as far as whether the candidature should remain between Raila Odinga and Uhuru Kenyatta. Of course, the judges did not respond to this question. It was never posed, so they did not apply their minds on that. But it's something that we'll be expecting to hear as soon as the application filed by Ekuru Okot is concerned, because he wants to be enjoined in the presidential candidature in the fresh election, arguing that IEBC made the wrong move in relying on the decision of 2013 that indicates that the fresh election should only be between a petitioner and the person whose election has been nullified. So there we have it. Raila Odinga, the National Super Alliance presidential candidate, walking to the podium to address the media. Let's listen in.
So you want me to... Yeah. Ladies and gentlemen of the media, I know it's been a long wait. We have sat in that court for nearly 12 hours continuously, including the judges. At least the advocates had moments when they could walk out for a break of 5-10 minutes, but the judges, all of them, sat from the beginning, from about 10:30 up to now, which has been a record 12 hours. I don't think in our history we have had a judgment or judgments read through this kind of period. But let me first thank our client, the petitioner, the two petitioners, the Prime Minister Raila Amolo Odinga and His Excellency Kalonzo Musyoka, for giving the legal team, a big legal team. I think we were more than nearly 30 lawyers and other professionals who undertook this work to prosecute this petition. It was not an easy task, and as you know, and as everybody has now come to acknowledge, that nowhere in the continent and in only 3 instances outside Africa has a presidential election been overturned. So I want to thank our team, which had very prominent lawyers, including senior counsels. I don't want to go through name by name. But I think we have proven that within the time stipulated for filing the petition and arguing the petition and coming out with a decision or a determination can be done. But we would agree with the sentiments that this law in relation to petitions should be looked at. But more important question is not just the victory that we have won. And I think this victory is a victory for the people of Kenya. It expresses the sovereignty of the people of Kenya that them, through Article 140 of the Constitution, made it possible for any qualified party to challenge a presidential election, which must be held in accordance with the Constitution. But the big question which has come out from this judgment is that the court has found, with a majority decision of 4 judges, that there was systemic and systematic violations of the law within the IEBC. And what they are saying is that the IEBC as an institution has a problem, and it committed illegalities and irregularities which made it possible for this decision to be rendered. Some of those illegalities were clear violations of the law, especially in the transmission of the results. And in the very, very well-articulated judgment of the majority, a lot of questions were posed as to how some of these forms 34A and 34B, and even the final form 34C, which was used to declare the results, that all those forms were either forgeries. It was put in a rhetorical way, but they were either forgeries or they were not genuine forms which had been printed as required with this required security features. So on that account, it has been established by a majority decision of this court, and that is the decision of the court, that there are those illegalities which now begs the question, is this the end of the matter? And our belief is that this is not the end of the matter. As you know, the chairman himself, consequent to what we raised in this petition, and through memos that has now been in the public domain, he has himself raised so many questions which border on some infractions of the law and criminal conduct on the part of the officials, some of the officials within IEBC. And some of these questions were directed to Mr. Chiloba, and he has made an attempt, and you know the chairman is working in very difficult conditions. He has made an attempt to either suspend or dismiss some officials within the IABC for specific reasons, including the director of ICT and 2 officials who had unauthorized access to the database using the chairman's password or authorization. This is a matter that requires full investigations, and the Director of Public Prosecutions did promise that at the end of this case and after the decision has been rendered, he is going to fully investigate this matter and bring the responsible parties to book. In our view, therefore, the IBC headquarters is for all intents and purposes a crime scene that should be preserved and documentation and materials preserved for purposes of carrying out these investigations. On our part, on the basis of what we have, we are prepared to give assistance to the Director of Public Prosecutions to ensure that the IBC as presently constituted does not include those who have authored these unfortunate violations of the law. And I want to finish before I hand over to the Prime Minister that the country may be bordering on a constitutional crisis of grave proportion. A constitutional crisis in the sense that the powers that the president would normally enjoy were extinguished very substantially on the 8th of August 2017. And after the 8th of August, he was exercising temporary powers of incumbency. And the danger that we now find ourselves in is that if the elections are not held within 60 days, then he will not have the constitutional authority or legitimacy to continue to be in that office. If you read the Constitution purposively and have a constructive interpretation of the Constitution, Articles 138 to 140, you will find that the president, when not constitutionally in office, there would be a requirement that you have an acting president who is not the incumbent president until an election is held. So this particular constitutional crisis that we are getting ourselves into must be resolved as quickly as possible. And that can only happen if we have an election conducted in accordance with the Constitution. And the IBC is not going to run away from it, because the court has spoken very loudly that they cannot conduct any other election except an election held and conducted within the provisions of the Constitution. And they said that if the IBC does not do that, if another petition is brought before them, they will make the same decision. So we have got two competing requirements, of that of holding the elections within 60 days from the 1st of September, or if an election is not held within 60 days, then the end of Uhuru's occupancy of State House or any other office, all other offices, physical offices, and constitutional powers ends at the end of those 60 days. I'm saying this because he did say that, he is still acting president until another president is elected. That is not the law. So with those remarks, I'll now call upon the Prime Minister to make his remarks.
I would like to thank the Kenyan judiciary for this historic ruling, because the ruling was done 20 days ago, but today they have given very comprehensive reasons supporting that ruling. As I said at the time when the ruling was made, it is historic for the African continent. We had an opportunity to meet with leaders of an association of African judges yesterday, and they all concurred with us that it is a beginning of a new era on the African continent. This is a major challenge to our country. And as I said last night, that the era of electoral autocracy must end in our country. In other words, that the people's vote must count. That Kenyans who have turned out to vote must know that their votes are eventually counted. Last time round, on the 8th of last month, millions of Kenyans turned out in the polling station to cast their votes. They, of course, expected that their votes were going to count. Unfortunately, by what has now been confirmed by the Supreme Court itself, those votes were manipulated at the tallying centers, at the constituency, and also at the national tallying center. And that, therefore, the vote did not amount to much. As you said, the computers then manufacture the leaders for the people of Kenya. This is what is unacceptable. And we now know that the same is what happened in 2013. And they used exactly the same formula to produce the leaders who are today shouting and hoarse their voices. They must know that they were beneficiaries of a very flawed process. And this is what they wanted to repeat again this time round. I am speaking on behalf of my colleague Stephen Kalonzo Musyoka, who was with me here, Honorable Salim Davadi, and Honorable Moses Wetangula, members of the summit of NASA. We have said that we are not afraid for another election. In fact, the campaigns ended and we are ready to go for the ballot. But we have said that we will not go to an election until the IBC rectifies all the mistakes which have now been confirmed by the court, until those individuals who are responsible for these criminal acts are brought to book, removed and prosecuted. Then we are ready to go for elections within 60 days. We also have said that the KIEMS system that was used to manipulate these results must be rectified. And that we have issues with a company called Safran Mofo, which was hired to provide those services. As you see, the court found the IBC and the service provider were in contempt of court. They were not able to give access to the servers as ordered by the court. Why? Because they were hiding something. This has been confirmed. The court also found that the forms that were used in recording the results were forgeries. They did not come from the printer. They did not bear the security marks which were required. We therefore have also issued with a company called Al Ghurair, which was contracted to print the ballot papers and the other materials used in these elections. So we are therefore saying that we want another contractor to be appointed. Time is available for all this to be done. I would like to take the opportunity to thank Kenyans and all our supporters countrywide who have stood with us during these very difficult and trying times in our country's history. Those who support change in our country. I want to assure them that we are with them, that we will stand with them until we finally reach our destination. Our journey to Canaan was sabotaged by these saboteurs. But we are definitely on our journey to our destination. And when the time comes, we will be able to reach Canaan. And therefore, keep the hope alive. We shall overcome and we shall eventually achieve our objectives. Wafuasi wetu wa Kenya, leo hii mahakama kuu imetoa uamuzi wake. Uamuzi waliofanya wiki 3 iliyopita, leo wametoa maandishi ambayo imeonyesha ya kwamba ushindi wetu iliibiwa. Imeonyesha kwamba uchaguzi uliofanywa haikuwa wa halali, na imekashifu tume ya uchaguzi kwa kufanya njama ya kuharibu uchaguzi vile ilivyofanywa. Kwa hivyo imesema ati Uhuru Kenyatta hakuchaguliwa kihalali, ilikuwa ni ushindi wa bandia. Kwa hivyo wamefutilia hiyo mbali na wakasema uchaguzi utarudiwa tena ndani ya siku 60. Tunatoa shukrani kwa mahakama kwa kuwa na ujasiri na kutoa uamuzi wa haki na kuonyesha ya kwamba Wakenya wana haki ya kufanya uchaguzi halali. Wamekashifu tume ya uchaguzi. Wamesema kulikuwa na maofisa pale ambayo walifanya njama ya kuharibu uchaguzi. Tunatoa shukrani hata kwa wale majaji ambao walitoa uamuzi tofauti. Hiyo ndio demokrasia, na kwa kufanya haya walisaidia demokrasia katika taifa letu. Tunasema kuna makampuni ambayo zilipewa kandarasi, kwa mfano ile ya kusambaza matokeo kutoka vituo vya kupiga kura, vituo vya kujumlisha kura na vituo ya kitaifa. Hiyo kampuni ya Kifaransa ambayo inaitwa Safran Mofo inaonekana ilifanya njama ya kuiba kura. Kwa hivyo tumesema hatutaki kuona kama kampuni hii ya Safran Mofo inabaki kama kampuni ambayo itasambaza matokeo ya uchaguzi. Tena kuna kampuni nyingine ya kutoka Dubai ambayo inaitwa Al Ghurair. Hiyo kampuni vile vile ilichapisha makaratasi bandia ambayo ilitumika. Na hiyo sababu tumesema hatutaki kuona kama Al Ghurair ndiyo itachapisha kura kwa uchaguzi inakuja. Sisi kama wananasa tuko tayari. Tulikuwa tayari jana kwa marudio ya uchaguzi, lakini tutashiriki ikiwa kama uwanja itakuwa iko sawa. Tumeambia hata wapinzani wetu na wale na ile tume ya uchaguzi, tunataka kuona kama kiwanja hii yale mashimo na mahandaki yamezibwa, yale mawe yametolewa, yale miba yametolewa. Tumeng'oa visiki vyote katika hiyo uwanja. Ikiwa iko laini, tuko tayari kuingia kwa kiwanja, tuonane na wana Jubilee mundu humundu. Tuko tayari. Natoa shukrani kwa Wakenya wote, wabaki macho. Ziara yetu ilikatishwa ya kuingia Kanani. Tuko gengeni. Tuna hakika uchaguzi kurudiwa, tutaingia katika nchi ya Kanani, wapende wasipende. Shukran, asanteni sana.
Are you surprised, Mr. Rengo, are you surprised that towards the end of the ruling, the CJ has said that they do not find any criminal capabilities by any IEBC official or any member of the Secretariat, and so there will be no criminal proceedings against them?
And how would you cross with it now that they have said so as a coalition?
No, you know, this is not a criminal court. An election court is not a criminal court. In fact, if you look at the laws that were amended last year and this year, we made the Election Offences Act a standalone act, which is within the domain of the Director of Public Prosecutions and other relevant government agencies. So once an election court has shown and demonstrated that there were illegalities, then it is upon the Director of Public Prosecutions to quickly move and take steps to deal with that problem. If you've read the Wetangula case, you remember they were referring to the Wetangula case very much. That is the principle which is there in that Wetangula case.
What if the DPP takes time in acting? What's the next move?
We had already said that if it doesn't act, then we intend to institute private prosecution. And already we are preparing ourselves for that. But within the week, we'll have a conversation with the Director of Public Prosecutions on that score. But there's something also I needed to say here, that, you know, the election court said that the IEBC, in response to the petition, they were jumbled. They didn't know what they were doing. Partly is because they did not appreciate the full effect of these laws that were changed last year. In fact, even Jubilee, I think, were living in another world until we came to court. You know, some of these changes that we made, courtesy of the election laws that were changed last year, the end of last year and this year, has made it possible for us to get footprints of these violations. If it was like the elections which was held in 2007, it was very difficult to get those footprints. But this one, you can see even the court is saying the best thing for IEBC would have been to open up and then prove the point that they had conducted the elections fairly and transparently. But they don't want to open those servers because they know that if those servers are opened, then I can confirm that Raila Amolo Odinga would be declared the winner of that election. So they will never open it for that reason. Yeah. Then he ceases to be president. He will not have authority, constitutional or otherwise, to act as president. That status and capacity ends at the end of 60 days. Because thereafter, there will be no fresh elections held in accordance with Article 140 of the Constitution. It will be a hunt for a new president of Kenya, and not Uhuru Kenyatta.
Tosha gari, wacha kama washibie watu nje.
Excuse me, yes, please ask. Yes.
If it is done properly in accordance with the law now, you cannot have a better election. This new system of elections, as established under Section 44 of the Elections Act, is the best for Kenya to guarantee a free and fair election. But my worry is if...
Why you're still saying that so certain officials have to be now we are also speaking maybe to prefer 60 days
separated by human beings.
without election.
The law requires if you commit an offense, you have to be arrested and prosecuted. You cannot have criminals running an independent commission. They have to be taken away. No, it's a condition for the elections. Yeah.
The issue is this. I think the question is asking is why do we have to change some of the officials if the laws are so clear? Are you listening? Yes. The reason we have to change those officials is because they failed to follow the law in the first place. And if they are not changed, despite the law being good, they might refuse to follow it again, and we'll end up exactly where we are. And that's why they must be replaced with those who respect the law and will follow the law. I think that was your question.
Do you have a certain timeline that will say by this date, within these 60 days, there will be, your demand will have been...
No. I think that question has been answered.
All right, we have NASA leaders there outside the Supreme Court addressing the media after a marathon 12-hour judgment. Good evening, I'm Jeff Koinange, and this is an abbreviated version of Jeff Koinange Live here at Citizen Television. Now, the Supreme Court has, just a few minutes ago, concluded its detailed judgment, confirming a majority decision to annul last month's re-election of President Uhuru Kenyatta. Chief Justice David Maraga led 3 of the judges to grant NASA presidential candidate Raila Odinga petition disputing Kenyatta's win. 2 other judges disagreed with the ruling in a minority opinion. Let's go live to our very own Sam Gituku, who has been at the Supreme Court for the last 12 hours straight. Sam, take it away.
Right, good evening, Jeff. It's been 12 hours, as you said. We've been listening to the judges make an account of why they decided the way they did. And just a recap of what has been happening is that the 4 judges who by majority decided to nullify the election of President Uhuru Kenyatta gave the account, essentially detailing the fact that they believe that there were illegalities and irregularities that were so grave that they necessitated no other decision but to nullify the presidential election of the August the 8th. And they have been saying that, of course, led by Chief Justice David Maraga, the Deputy Chief Justice Philomena Mwilu, and of course Isaac Lenaola, the Justice of the Supreme Court, and in absentia Smoking Wanjala, who is also a judge at the Supreme Court, explaining that IEBC, in a great sense, led by the returning officer of the presidential election of Wafula Chebukati, failed to adhere to the law and the provisions of law, essentially saying that in as much as the Court of Appeal, in a decision that it rendered sometimes in June, to the tune that the presidential election results that have been declared at the constituency level, they are final. The judges by majority are saying that in as much as that is true, it does not take away the responsibility of Wafula Chebukati as the chairperson and the returning officer of the presidential election from verifying, and so he needed to ensure and take charge of all the Form 34As from the polling stations and receive them to confirm that indeed the figures that had been indicated in a Form 34Bs then are the same figures that had been granted, rather as assigned in the Form 34As. And so he says that the other matter to do with the transmission of presidential election results, it was not verifiable. You remember that there was a scrutiny of the presidential election transmission system, the results transmission system that had been ordered by the court, and the judges said that it was not satisfactory to say that the election could not be verified, the results that had been transmitted by the system could not be verified. But on the other hand, the other 2 judges, that is Justices Professor Jackton Ojwang and Njoki Ndung'u, Supreme Court judge, giving dissenting opinions, that is in their respective judgments totaling to 2. They are saying that you cannot use the results transmission to base it as a basis, to give it as a basis of nullifying a presidential election. For instance, Njoki Ndung'u, the presidential, or rather the Supreme Court judge, says that according to her finding, the IEBC officials led by the returning officer Wafula Chebukati adhere to the rules in the sense that they respected the ruling of the Court of Appeal that the results at the constituency level are final, and so the responsibility of Wafula Chebukati, the returning officer, was to take an account of the returning, or rather the reports returned from the constituencies, the 291 Form 34Bs from the 290 constituencies in the country, and also including the 291st, the diaspora, and that was done. She also says that the role of Wafula Chebukati at that point was to ensure that he is in a position to tabulate the results from the 290 constituencies, ensure that there is the national threshold of ensuring there is at least 50% plus 1 vote for the president-elect to be declared, and also ensuring that the winning candidate had gotten at least 25% of the vote from 24 counties. But she sort of gave a new account that has not been mentioned by the other judges, in the sense that you remember during the scrutiny report presentation before the court, it was said that some of the Form 34Bs from some constituencies did not have the security features that were required. They didn't have the barcodes, they didn't have the signing, they didn't have the stamping. And case in point, were 3 constituencies at the course that is Likoni, there was the constituency in Kisauni and Nyali, which were mentioned by the scrutiny report that was presented by the Registrar of the Supreme Court, indicating that they did not have all those requirements. But Justice Njoki Ndung'u says that after retiring from the hearing, from the courtroom, she went ahead to peruse through the documentation that had been filed by IEBC. You realize that according to the rules and procedures that govern the hearing of a presidential election petition, the IEBC is required that within 48 hours of the filing of a presidential election petition, they must file the documentation of the election at the Supreme Court within 48 hours. So the judge says that after retiring from the hearing, she went ahead to look for the forms from Nyali constituency, Kisauni constituency, and the other third constituency, which is to do with, I said, Nyali, Kisauni, and Likoni. She was able to look at them, and they had all the security features that were required. They had been signed by the returning officer. They had been signed by the presidential election agents for the two candidates, Raila Odinga and Uhuru Kenyatta. And so she says that there is no basis for nullifying the election. She says that the interpretation by the majority view, the majority of the judges of the Supreme Court is narrow. The interpretation of the law governing the presidential election is narrow and should not have gotten to the point that the country is in a nullified presidential election. And the argument by Professor Jackton Ojwang, the other justice who is dissenting, is so similar to what has been adduced before the court by Justice Njoki Ndung'u. For Ojwang, he says that there was no proper consideration of the evidence that had been leveled by the respondents. In this case, we're talking about the IEBC and also talking about President Uhuru Kenyatta. And so both of them say that it was not sufficient to warrant a nullification of exercise because essentially the voters woke up on the 8th of August and they went to their polling stations. They made their judgment, or rather they made their decision by ensuring that they voted. And so the errors, the shortcomings from the presidential election results transmission system should not have been used to nullify the election. But in the end, Jeff, what matters is the majority view. And the majority view of the four judges is that the presidential election stands nullified and a fresh one has to be held by the 31st of October, which is the time that the 60 days that have been granted by the court and also granted by the Constitution, that is when they will be lapsing. So it is upon the IEBC to hold that election and ensure that it is in accordance with the provisions of law and the Constitution. But something just to add is that there has been a question in as far as whether there is criminal culpability, and this is one of the things that the National Super Alliance has been talking about towards the end of their press statement from James Orengo and Otiende Amolo, who are counsels who are representing the petitioner Raila Odinga before the court. And the argument has been that the IEBC officials who are involved in this process need to take responsibilities. Some of the officers need not to oversee the election, but the judges, by majority, again, the final orders that were granted, or rather that were given by Chief Justice David Maraga, saying that they did not find sufficient evidence to see that there was any malicious, or rather there was any criminal culpability on the side of the returning officer, Wafula Chebukati, on the side of any of the other 6 commissioners, and also from any member of the IEBC. Any member of the IEBC may be interpreted to mean the staff of IEBC, but of course the judges have spoken. The politicians will have their day, and the Kenyans will have a day to go and cast their ballot and decide who becomes the president of Kenya. Jeff?
All right, Sam, you just answered most of the questions I had for you, but one quick one, which you may not have the answer. Is October 17th out of the question? Because it's only 27 days away now, Sam.
Well, that's a good question and a tough one, but let me respond to it in this way. Just before the judges left the courtroom, there was an application by a lead counsel for IEBC, Paul Moite. He was saying that they wanted the court to grant orders to enable IEBC to open the ballot boxes that were used in the August 8th election because they need to use those ballot boxes, and they felt that the material in there is of no use, bearing in mind that the election that was used for those materials has already been nullified. But of course, there were contestations from members of representing Raila Odinga and representing Uhuru Kenyatta, saying that there is a statute, there is a law that requires that the materials of an election have to be preserved for at least a period of 3 years. So you cannot go ahead to open the ballot boxes and get to use the same ballot boxes without preserving the content of those ballot boxes. But eventually, Paul Moite withdrew that request, saying that they'll eventually go to purchase the ballot boxes. So where am I heading with this? You realize that the argument by Paul Moite was that they don't have sufficient time and they need to procure ballot papers, but they were looking to be granted the leave to go ahead and use the same ballot papers. But now they have to make sure that they procure new ballot papers. There are some other things that they need to do. For instance, they have to reconfigure the KIMS gadgets. These are the devices that are used for the identification of voters and also transmission of results to the various tallying centers at the constituencies and the National Tallying Center. Of course, there has been that argument that OT more for the French firm that was procured to supply these services is not ready to give an election on the 17th of October. So they have been requested for more time so that they have enough time to reconfigure the kits and also preserve the information, the data within contained in those KIMS kits. So it's not certain whether we'll have an election on the 17th of October. Of course, we'll be expecting to hear from the IEBC probably tomorrow as they react to the judgment. You realize that as one of the excuse or one of the reasons that have been given by the Commission in as far as preparing for the election has been that they do not have the full account of the judgment. But now they do have it, so we'll be expecting to hear from them. Really, will you have the election on the 17th of October, or should we have it on another day, bearing in mind that the time we have goes up to the 31st of October? Jeff?
Sam, appreciate that. You've done a great job today. Get some rest. Sam Gituku there, live from the Supreme Court after a 12-hour marathon session. Now, speaking of Supreme Court, the Supreme Court says it has found no evidence incriminating the Electoral Commission officials in criminal acts in the annulled election. The verdict is likely to be received with much relief by IEBC officials led by CEO Ezra Chiloba, who have been the target of the opposition coalition demands for sacking and prosecution for allegedly bungling the poll.
Although the petitioners claimed that various electoral offences were committed by officials of the first respondent, that's IEBC, no evidence was placed before us to prove that allegation. What we saw in evidence was a systematic institutional problem, and we were unable to find specific fingerprints of individuals who may have played a role in the commission of illegalities. We are therefore unable to impute any criminal intent or culpability on either the first or second respondent or any other commissioner or a member of the first respondent. We are simply unable to find any evidence of misconduct on the part of the third respondent. The prayer is therefore disallowed. By majority of 4, with just Ojwang and just Jokindungu dissenting, we make the following orders. A declaration is hereby issued that the presidential election held on the 8th August 2017 was not conducted in accordance with the Constitution and the applicable law, rendering the declared results invalid, null and void. A declaration is hereby issued that the illegalities and the irregularities in the presidential election of the 8th August 2017 were substantial and significant, that they affected the integrity of the election, the results notwithstanding. A declaration is hereby issued that the third respondent was not validly declared as the president-elect, and that the declaration is invalid, null and void. An order is hereby issued directing the first respondent to organize and conduct a fresh presidential election in strict conformity with the Constitution and the applicable election laws within 60 days of this determination. On 1st of September 2017, under Article 140 of the Constitution. Regarding costs, as I've said, each party shall bear its own costs.
Okay, Chief Justice David Maraga there. Now, earlier in the day, the Supreme Court outlined in detail reasons for invalidating President Kenyatta's re-election and blasted the Electoral Commission for conducting what they call an opaque election. Chief Justice David Maraga and his 3 colleagues said the election was not conducted according to the law and ruled that IEBC disobeyed its order and failed to prove that its systems were not hacked. And as Francis Gashuri reports, the judges said they would go ahead to nullify another election if it is not held according to the law.
Their comprehensive judgment was eagerly awaited amid a barrage of criticism from the ruling party for allegedly conspiring with the National Super Alliance and a section of the civil society to nullify President Uhuru Kenyatta's triumph at the ballot against his main challenger Raila Odinga.
The electoral system in Kenya today was designed to be simple and verifiable. Between the 8th of August 2017 and the 11th of August 2017, it cannot be said to have been so. The petition before us was, however, simple and to the point. It was obvious to us that IEBC misunderstood it, hence it jumbled up responses and submissions. Our judgment is also simple and, in our view, clear and understandable. It ought to lead IEBC to a soul searching and to go back to the drawing board.
The Chief Justice, his Deputy Philomena Mwilu, and Judges Isaac Lenaola and Dr. Smoky Nwanjala held that the presidential election was conducted in such an opaque manner, in blatant violation of the election laws, that the results could not stand.
The illegalities and irregularities committed by the first respondent were of such a substantial nature that no court, properly applying its mind to the evidence and the law, as well as the administrative arrangements put in place by IEBC, can in good conscience declare that they do not matter and that the will of the people was expressed nonetheless.
At the heart of Odinga's petition was a claim that IEBC results transmission system had been infiltrated and the outcome doctored in Kenyatta's favor, the judges holding that IEBC lost a golden chance to debunk the allegations when it failed to open up its servers and avail the necessary logs as ordered by the court.
IEBC's contumacious disobedience of this court's order of 28 August 2017 in critical areas leaves us with no option but to accept the petitioner's claims that the IEBC's IT system was infiltrated and compromised, and the data therein interfered with, or IEBC's officials themselves interfered with the data or simply refused to accept that it had bungled the whole transmission system and were unable to verify the data.
While the polling process was flawless, up to the counting and announcement of results at the polling stations, transmission of the poll outcome was the challenge, with the judges heaping blame on IEBC for failing to comply with the law on electronic transmission and verifiability of the results.
The failure by the first respondent to verify the results in consultation with the second respondent before the latter declared them, therefore, went against the expectations of Article 138(3)(c) of the Constitution, just as the failure to electronically and simultaneously transmit the results from all the polling stations to the National Tallying Center violated the provisions of Section 39(1)(c) of the Elections Act.
Authenticity of the results declaration forms was yet another factor the judges relied on while invalidating Kenyatta's re-election.
What is this court, for example, to make of the fact that 290 out of 290 Forms 34B that were used to declare the final results, 56 of them had no security features? What had the security features touted by the first respondent disappeared to? Where had they disappeared to? Could these critical documents be still considered genuine? If not, then could they have been forgeries introduced in the vote tabulation process? If so, with what impact to the numbers? If they were forgeries, who introduced them into the system? If they were genuine, why were they different from the others?
Even the Form 34C that IEBC Chairman Wafula Chebukati used to declare the final presidential outcome had authenticity questions, with the 4 judges blasting him for failing to verify the results.
This form As crucial as it was, bore neither watermark nor serial number. It was instead certified as being a true copy of the original.
The 4 judges have since the 1st of September verdict been accused of effecting a judicial coup by lowering the threshold in annulling a presidential resort.
If not, this court were ever called upon to adjudicate on a similar dispute, will reach the same decision if the anomalies remain the same, irrespective of who the aspirants may be. Consistency and fidelity to the Constitution is an unwavering commitment this court makes.
With a repeat presidential election expected within 41 days, IEBC was challenged to carry out its mandate in strict compliance with the law. The Supreme Court judges in a majority verdict have equated the presidential election to a mathematical sum where the answer is as important as the formula. And in this case, the presidential poll outcome is as important and critical as the process, and that they will not hesitate to annul future presidential elections as long as IEBC fails to comply with the laid down regulations in the election laws and the Constitution. Francis Gashuri, Citizen TV, Nairobi.
All right, thank you, Francis. Now, call it a sting operation. A swarm of bees descended on demonstrators outside the Supreme Court, averting a clash between Jubilee and NASA supporters. Hassan Mugambi reports on the day's bee drama.
Talk about a sting operation. It was a question of every man for himself and God for us all outside the Supreme Court Wednesday. A swarm of bees literally rained on demonstrators as they engaged police in running battles.
And as the back and forth ensued between officers and demonstrators from both parties, a contingent of unexpected officers in form of bees attacked and spared no one.
While I was successful to avoid the stings, many were not as lucky. The bees spared no officer in uniform. Armed as they were, they retreated with their heads down. No seniority registered here as Langata OCPD Elijah Mwangi was caught in the chaos, forcing him to drive away. Speed was of the essence for journalists who found themselves in the swarm. This photographer receiving one right in front of our camera. Not just her. Not even this police horse could keep calm in the melee. The bees triggered gallops. This officer, however, braved the bees to come to the aid of this person with disability. Sergeant Edward Opicho, attached to the anti-mugging unit, was however forced to retreat when he could not bear it anymore. The man was finally whisked to safety and rushed to the hospital where he is undergoing treatment. The bee attack came about after this group of demonstrators supporting Jubilee Party came into confrontation with NASA supporters. Police hurling tear gas to disperse them. Hassan Mugambi, Citizen TV.
Thank you, Hassan, for that stinging report. We're going to take a quick break now, come back. Business news ahead and also a recap of the day in sports. This is Jeff Koinange live right here at Citizen Television. Take a break. We'll be back in a moment.